Yes. Good evening, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the Supreme Court Advocate on Record Association to this last lecture of the SCORA lecture, AOR lecture series 2025. Today, we've all gathered here for one of the important exam of leading cases in the upcoming AOR examination, wherein our esteemed speaker will enlighten us on minority rights and right to education. We have the honor to have with us today Senior Advocate Chandaruday Singh, sir. We welcome you, sir, and we are thankful to you for taking out time and discussing the cases of TMA Pai Foundation versus State of Karnataka, PA Inamdar versus State of Maharashtra, Indra Sawhney versus Union of India, National Legal Services Authority versus Union of India, State of Punjab versus Davinder Singh, and Pramati Educational and Cultural Trust versus Union of India. We're showcasing this lecture live on YouTube, and if anybody has any questions, the same may be put in the chat box and the same will be taken up in the end by Sir. I now would have a pleasure to introduce Sir. Senior Advocate Chandaruday Singh, Sir, is a senior advocate practicing in the Supreme Court of India. He was a late entrant to the practice of law. Having earned a bachelor's degree in commerce, he started out by returning to his agriculture roots and ran a crop farm in Punjab, followed by a small dairy and mill supply business in Haryana and Delhi. He then worked as a journalist, and during his 4-year stint with that magazine, he earned his bachelor's degree in law from the Government Law College, Bombay. He was enrolled as an advocate in September 1984, and after 4 years of trial work in the labor and industrial courts, he practiced primarily in the Bombay High Court for the next 2 decades. C.U. Singh, sir, was designated as a senior advocate in 2005, and in 2009, he shifted full-time to Supreme Court of India. He has appeared as a counsel in broad array of cases ranging from constitutional challenges like Article 370, reservations of the Marathas, to public causes like the Aadhaar challenge, national anthem case, LGBTQ rights, and a challenge to the beef ban in Maharashtra, to the employment law matters, and of course, to a variety of commercial causes. Sir has appeared in a range of commercial matters arising from corporate disputes, arbitration, alternate dispute resolution, insolvency and bankruptcy court, power generation, electricity regulation, property disputes, and regulatory matters. He is a regular counsel for the Securities and Exchange Board of India. I'm confident that today's Sir's lecture will actually provide an invaluable insight and perspective to our discussion today. Please join me in welcoming Senior Advocate C.U. Singh, sir. Over to you, sir. Please start with your lecture.
Thank you. Thank you, Dr. Kalra. So I'm going to start with in the judgment of the 9-judge bench in Indra Sawhney versus Union of India. Not just because it is chronologically the first out of the judgments that I'm supposed to deal with in today's lecture, but also because this judgment then led to a development of the law on reservations in general, and this was a very seminal and very important judgment in the march of the law with regard to reservations, especially reservations in education and reservations in services, which is broadly the subject matter of the remaining judgments which I'm dealing with today. So Indra Sawhney versus Union of India was a 9-judge bench judgment. It was 9 judges of the Supreme Court at the time when Justice M.H. Kanya was Chief Justice of India, and the judgment was dealing with in 1992. The court was faced with a situation where there was very little clarity on various aspects of Article 16 of the Constitution of India with regard to reservations in services, and what should be particularly certain aspects such as whether there could be an exclusion of people within a reserved category, whether there could be some exclusion of those who have already attained a level of achievement or a level of standing in society from within the backward or depressed class. So whether there could be an exclusion of persons was one aspect, which was wide open at that time. The Supreme Court had never really, in N.M. Thomas, etc., they had glancingly dealt with these issues. but there was a lot of uncertainty and a lot of conflicting judgments on these aspects. There was also the question of whether the state can make reservations under Article 16(4) in addition to scheduled castes and scheduled tribes, which are already provided for under Article 16(1). And also, what would be the scope of judicial scrutiny when the state makes reservations? And so all these aspects were dealt with in Indra Sawhney. This is 1992, Supplement 3 SCC 217. So the main judgments, the most important judgments within this nine judges' judgments were the judgments, I would say, of Justice Jeevan Reddy, who spoke for four learned judges out of the nine. Justice P.B. Sawant, who has given a great deal of clarity to the issues involved, and Justice Kuldeep Singh, among others. But these are, I would say, the most important speeches within the judgment which need to be considered. So, if I could just highlight a few aspects, Justice Jeevan Reddy's opinion begins at page 631. The judgment, as I said, is 1992 Supplement 3 SCC 217. And Justice Jeevan Reddy's opinion begins at page 631. So it's a very, very large judgment. It takes up the entire volume. And Justice Jeevan Reddy spoke for himself, for Justice M.H. Kanya, who was CJI, Justice M.N. Venkatachalaya, and Justice A.M. Ahmadi, as well as himself. And Justice Reddy examined, he formulated, speaking for the majority in a sense of he formulated a series of questions at para 681, at page 654. 11 questions, if I remember right, or 8 questions were framed by Justice Jeevan Reddy. And starting with whether Article 16(4) was an exception to Article 16(1), or whether it was a means of effectuating the requirement of Article 16(1), whether 16(1) is exhaustive and nothing can be added by a state under 16(4). What is the meaning of backward classes within 16(1) and 16(4), and whether there can be a sub-classification between backward classes of most backward or less backward, etc., etc. These are the 8 questions framed at para 681 at page 654 of the judgment. And ultimately, Justice Jeevan Reddy formulated, speaking for the bench of for 4 learned judges, and I'll show you that this is then concurred with. Broadly, these formulations were concurred with by Justice P.B. Sawant as well as Justice Kuldeep Singh, and the majority, the overwhelming majority of the 9 judges concurred with these views. Ultimately, what was framed by Justice Jeevan Reddy in broad terms, not going into the nitty-gritty, was that there has to be a balancing between the need for reservation in order to uplift and lift up the backward classes, and the need for maintaining a chance of success based on merit of the people who are based on merit alone. That is either whether you are backward and purely meritorious, or those who are meritorious from the non-backward classes. How are their chances to be maintained? Because what had happened was that several states had started giving very large amounts of reservations to the extent of 70, 80, 65%, 70%, 80% of the posts were being reserved. And there were hardly 15, 20, 25, 30% were being left for all the other classes put together. And with the result, that there was a lot of heartburning, a lot of heartache caused for those who were not beneficiaries of the reservation under Article 16(1) and 16(4). So Justice Jeevan Reddy ultimately formulated this principle, which then has now held the field over a very long period of time, that ultimately a ceiling would have to be made, put on the extent of reservations. And if that ceiling was put at 50% of the posts, then the Supreme Court said it will not violate Article 14. But if the reservations exceed 50% of the posts, for instance, if there are 100 posts and 75 posts are given for the reserve classes alone, the Supreme Court, Justice Jeevan Reddy said that that will violate Article 14 as well as Article 16(1), the main part of Article 16, which is the need for having absolute equality between people. That equality principle will be violated if you have reservation in excess of 50%. So this was the very important aspect. And if you can note down the part 5 of Justice Jeevan Reddy's opinion, which is from page 731, answering question number 6, 7, and 8 of the 8 questions which he had framed. He said to what extent can reservations be made, and whether the 50% rule enunciated in Balaji was only a rule of caution or rule of prudence, or whether it could be made into a binding rule traceable to the Constitution of India and be made into an absolute barrier, and whether the 50% reservation would apply only to 16 for reservations or to all reservations under Article 16. And there were certain ancillary aspects about whether the year should be taken as a unit or the continuing, backlogs, etc. All should answer that particular aspect. And ultimately, the conclusions, Justice Jeevan Reddy's conclusions, are in part 7 of the judgment at page 766, para 859. He summarized the answers to all the 8 questions very succinctly, and basically they evolved this concept of 2 or 3 concepts. One was that 50% was an absolute ceiling, and reservations in excess of 50% would be treated as unconstitutional or ultra vires the constitutional requirement of Article 14, read as Article 16(1). Secondly, they formulated a principle of creamy layer. They said that where the state gives reservations, apart from scheduled castes and scheduled tribes, where the state gives reservations to other backward classes under Article 16, sub-Article 4, under Clause 4 of Article 16, and the state decides to give reservations to other backward classes, then the state would have to undertake an exercise to identify the creamy layer in the other backward classes. The creamy layer was basically defined like if you take a glass of milk, hot milk, and slowly the cream rises to the top. So all the best and richest part of the milk rises to the top in the form of the cream. And the lower part is a thinner form of milk, which has much less cream. So nowadays everybody wants toned milk and skim milk and doesn't want the cream. But the basic element that they developed, the creamy layer theory, was that if people have already benefited from reservation, if, for instance, there's a person who has belongs to other backward class and has got reservations either as a nomadic tribe or as other backward class or whatever, and has risen by virtue of reservation, has risen in IAS to post of secretary or joint secretary or additional secretary, or in IPS or in some other service or in a state civil service, that person's children obviously would have a better chance in life than the other members of the same backward class. In other words, suppose you take Vimukta Jati or nomadic decriminalized tribes. Now, within them, those who have got the benefit of reservation, one generation has got reservation and risen up in the society, that person's children would obviously be much better off than all the fellow members of the Vimukta Jati or nomadic tribe or decriminalized tribe of the very same tribe. So why should that person's children take the benefit of the reservation as opposed to the poorer people and the disadvantaged people within the same backward class? That is how they said the creamy layer. Now this has become again a part of our reservation system. So these, I would suggest that you read this part 7, para 859, which is summarized at page 766. Just read only that, the conclusions, and you will get a very clear idea of what were the principles which have been culled out by the Supreme Court. And then in para 860, at page 769, having laid down 14 principles in answer to all those questions, they gave a question-wise answers to the 8 questions earlier framed in para 860. So if you just read para 859 and 860 at page, as I told you, page 700 and 766 is para 859 and 769 is para 860. These two paras will give you a whole broad idea. Now, Justice P.B. Sawant, his one of the very important parts of his view is in at page 557 of the same judgment, in his answer to question 6, which is that whether Article 16 for reservations can be given by the state by a simple order of the state, or whether it requires a law to be made by the legislature of the state. And the judges held ultimately that it requires a law to be made by the legislature of the state to give reservations to other backward classes, and that law must also be based on some objective criteria, on a study which is done, etc., to determine the actual backwardness of the that particular class, and so on. Then there are certain dissents and so on. There's Justice Kuldeep Singh opinion and all, but I'm not going to take a lot of time over that because time is going to be limited. And so I'll close with on Indra Sawhney on this. If these important aspects can be kept in mind, and also take a look at the conclusions of Justice Kuldeep Singh. Justice Sahai was a dissenting opinion, and there are one or two other dissents, but I don't think you need to worry too much about that aspect. Now, the next very important judgment that we come to is the judgment of another 9 judges bench in TMA Pai Foundation. And TMA Pai Foundation is versus TMA Pai Foundation versus State of Karnataka is in 2002, Volume 8, SCC 481. This was when Justice B.N. Kirpal was Chief Justice of India, and Justice Kirpal, in fact, has authored the main opinion of the majority of the bench, and it's a very, very erudite opinion. Now, here certain the questions which arose before the Supreme Court here were not to do with reservation, but to do with whether the rights of minorities and rights of aided and unaided schools to could be curtailed by number one, by forcing reservations upon them, and number two, by whether rules and regulations and so on could be made in a manner which takes away which sort of impinges on the rights of the minorities to manage their institutions. There had been a spate of judgments of the Supreme Court right from the inception of the Constitution, virtually on Articles 29 and 30 of the Constitution, with regard to the rights of the minorities to educate their children, whether it's a minority, or a linguistic minority, or a religious minority. And those rights are very jealously guarded by Articles 29 and 30. That led ultimately to a disparity of opinions, etc., in various judgments of the Supreme Court. And ultimately, TMA Pai Foundation settled a lot of those questions. And Justice Kirpal's judgment, which is the leading judgment in this particular case, is ultimately formulated. He formulated 11 points or 11 questions, including what is the extent of interference which can be there by the state in educational institutions, whether minority educational institutions have a right to be completely exempt from state regulation, or whether they have to comply with state regulations and so on. And broadly, I'll come to the nitty-gritty of it. But broadly, the bench held in TMA Pai Foundation that they followed Ahmedabad St. Xavier's, which was also a 9-judge bench in the 1970s. and several other judgments, but they followed them to the extent that the right of the minorities to administer their educational institution is a very, very strong and very jealously guarded right in the Constitution. But that right does not extend to the right to maladminister their institution. So the regulations which are framed by the state, by laws framed by the state, to the extent that they lead to better administration and better quality of education, those laws to that extent that prevent maladministration by the minorities of their educational institutions, the Supreme Court said such laws would be valid. But let me just add a caveat here. Basically, what the Supreme Court was saying was that the state can frame laws which lay down standards. They can lay down minimum benchmarks. They can say that you will not hire a teacher who does not have a teaching qualification. You will not hire a professor in a college who does not have a PhD. You will not hire a so and so who does not have this or that or the other. But they cannot make laws which say that if it's let's say it's a Hindi linguistic institution in the state of Maharashtra, and it's therefore a linguistic minority institution in Maharashtra, or a Hindi institution in Tamil Nadu, or a Muslim institution in any state where the Muslims are in a minority, or and so on and so forth. There, the court took the view that you can't tell them to hire a person of the choice of the government or from a panel made by the government. You can't tell them to not hire people who belong to that particular minority. Like if it's a Hindi linguistic minority, you can't tell them not to hire people who are learned in Hindi and who come from institutions of excellence, with degrees from good institutions which have trained them in Hindi. Similarly, if it's a Urdu institution, you can't tell them to take people who are not trained in Urdu and take them just because they have got a management degree or a PhD in some nuclear science or something. So you can lay down minimum benchmarks, you can lay down standards, you can lay down all things which to do with the quality of administration, but you cannot. In other words, you can prevent maladministration, you can prevent misadministration, but you can't interfere with the day-to-day management and running of those institutions. This is broadly speaking what was held in TMA Pai. Most importantly, TMA Pai drew a distinction between aided and unaided institutions. They also took the view that when institutions seek government aid, then to the extent that the government, when it gives aid to the institution, to the extent that there are certain rules and regulations which are framed for the purpose of giving aid, they will have to comply with those rules and regulations. They will have to fall within the parameters for getting the aid and so on. They can't say that I want the aid, but I will not comply with X, Y, Z. But at the same time, even then, their right as minorities will not be taken away, the right to administer, merely because they are getting state aid. They'll be subject to a much greater degree of state interference than an unaided institution. As far as unaided institutions are concerned, TMA Pai put minorities and non-minority institutions virtually on the same par, that if you are totally unaided, you're totally autonomous, you're raising your own funds as an institution or as a minority or as a group or whatever, and you're not seeking any aid whatsoever from the government, then there should be absolutely minimal interference by the state in the running or administration of such educational institution. Minimal interference in the sense, again, you can lay down standards for minimum standards of qualification and so on and so forth, so that they are not some complete dapoos who are coming and teaching over there. But more than that, you cannot do. In unaided institutions. You cannot interfere at all with the administration, even to the extent that you would be able to do in aided. In unaided, you cannot, whether they are minority or non-minority, they would have complete autonomy to run. So the answer, Justice Kirpal's answer, he frames 11 questions, and if you see page 587 of this report, at the foot of para 161, Justice Kirpal sets out the answers to the 11 questions which are framed. What is a minority? What sort of what are religious minorities? What are non-religious minorities? Whether professional education comes within minority education, whether that is also protected by Article 30, etc. The right to administer, to the extent, to what extent is it absolute? To what extent can there be some interference under Article 29(2) and 31 with the minority institutions? Whether admissions to the of students can be interfered with, whether and so on and so forth. So this is a very sweeping judgment. It dealt completely. It was a sort of a almost like a last word as far as all those questions, those 11 questions which were framed by Justice Chief Justice Kirpal are concerned. Justice Khare gave a concurring opinion at page 591. Justice Kadri gave a partly dissenting opinion at page 617. Justice Rumapal gave a partly dissenting opinion, and Justice Varyava, who was speaking for himself, and Justice Bhan also gave a partly dissenting opinion at page 668. But the view of Justice Kirpal, Chief Justice Kirpal, is, as I said, summed up in at page 587, at the foot of page 161, para 161, and all the 11 questions are answered very, very elaborately. And it would be worth taking a look at that to get the sense of TMA Pai. Now, soon after TMA Pai came the judgment of the Supreme Court in PA Inamdar. Now, PA Inamdar was a judgment of 5 judges. And here the main issue was with regard to recognition of institutions, whether when they seek recognition of their degrees and so on, whether minority institutions which are unaided and yet require the recognition of their degrees and so on, or they require to be affiliated with universities or affiliated with a schooling system like SSC or HSC or ICSC or whatever. What is the extent of interference which can take place and so on? Because what had happened was after TMA Pai, there was a judgment of 7 judges in Islamic Academy, or was it 5 judges in Islamic Academy, which had sought to water down TMA Pai considerably on certain aspects. So PA Inamdar was this 5 judges bench of PA Inamdar, which was when Chief Justice Lahoti, R.C. Lahoti was Chief Justice of India. They examined the questions in order to settle the law which had become somewhat unsettled by Islamic Academy. And ultimately at page 599, para 115, the court, Chief Justice Lahoti set out his answers to all the questions which had been framed and to settle the law which had been, as I said, somewhat unsettled in the case of Islamic Academy. They also then so from page you can take a look, especially from para 115 to para 125. With regard to the main aspect. The other aspect, and para 130, they expressly disapproved of Islamic Academy, where the state had taken up the right to fix quotas and to enforce quotas even in minority institutions and so on. Then they separately dealt with this whole question of NRI seats in medical institutions and engineering institutions and all, where there was this private institutions were permitted under TMA Pai to give seats to NRIs and so on. So that was separately dealt with in para 131. And then admission procedures are dealt with separately from para 133 onwards. So fee regulation, capitation fee, etc., all of that was dealt with in PA Inamdar. But Inamdar is important because they categorically said that so long as an institution does not charge what is called capitation fee. Capitation fee means something over and above the fees which are reasonable and normal and give a reasonable profit to an institution. When you take a huge amount from one student, to jump the queue over others. Suppose the normal fee for everybody is 1 lakh per year. And you say, okay, if you give 20 lakhs, then you can jump the queue and you can come in regardless of merit. That is a capitation fee. They said that so long as an institution does not have capitation fee, the fixation of fees is totally the right of the minority institution or the right of an unaided institution. That is, they have total freedom on that, except where they have capitation fees. And those answers were then set out by the court in para 144 onwards. So this is as far as PA Inamdar is concerned. Now, what happened thereafter was that to get over PA Inamdar and to get over this thing that there was absolute liberty of unaided institutions as given by TMA Pai, watered down in Islamic Academy, reintroduced by PA Inamdar, the Parliament then framed the Parliament passed the 93rd Amendment Act in the year 2005, which is the 93rd Constitutional Amendment, the 93rd Amendment to the Constitution in 2005, by which Clause 5 was inserted in Article 15. Article 15 is the article which gives equality in education, prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth, and various principles were laid down in 15.1 to 15.4. Now, by the 93rd Amendment, 15.5 was inserted, and this significantly sort of gives the state more powers and watered down the principles, some of the principles laid down in TMA Pai and PA Inamdar. So basically, it was TMA Pai and PA Inamdar were largely based on Article 19(1)(g). That is the freedom to carry on business and to the right to carry on business, because it was on that basis that they had said that unaided institutions cannot be interfered with. Now, here what the Supreme Court said what Parliament said by inserting Clause 5 in Article 15 was that nothing in this article or subclause G of Clause 1 of Article 19, that means 19(1)(g), nothing in Article 15 or in 19(1)(g) shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes or the scheduled tribes insofar as such special provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30. And nothing in this article or 19(1)(g) or Article 29(2) shall prevent the state from making any special provision for the advancement of any economically weaker section of citizens other than the classes mentioned in 4 and 5, and special provisions for advancement of economically weaker sections, etc., for admissions to educational institutions, including private institutions and so on. I'm not reading the entire thing, it's a lengthy clause. Here, basically, the principles which we had seen evolving first in Indra Sawhney, then in TMA Pai, etc., those principles, insofar as they kept private educational institutions and minority institutions out of the sphere of interference by the state. Article 15(5) left out minority institutions, but brought in all other private educational institutions, whether aided or unaided. So this completely cuts away from what was laid down by the Supreme Court in TMA Pai and reasserted in PA Inamdar. So this then, this 93rd Amendment came up was challenged before the Supreme Court before a constitutional bench in Pramati Educational and Cultural Trust, which is 2014 8 SCC page 1. And in Pramati, broadly, the Supreme Court, the constitutional bench holds that Article 15(5) gives the power to, first of all, they upheld the validity of Clause 5 of Article 15. They said that this is not ultra vires, it does not defeat Article 15.1. 15.1 requires total equality. 15.5 is saying that we will give reservations, etc., etc., even in unaided institutions, even in private institutions, we'll take away the 19.1G protection and so on. So the argument was that 15.5 violates the main provision 15.1. Supreme Court said no, it does not violate the main provision. It is in fact in furtherance of the main provision. It is a way of effectuating or giving teeth to the main provision of 15.1, and it's an enabling provision to achieve the objectives of 15.1. Then they said that so far as 19.1G is concerned, 15.5 does not violate 91G. On the contrary, it constitutionally supersedes 19.1G. Because 19.1G says that subject to laws made, a reasonable law made, subject to any reasonable restriction, the right to carry on business will be absolute. And 19.1G, in 19.6, there is a 5 or 6 or 7 exceptions where reasonable restrictions can be laid down. So Supreme Court held here in Pramati that this 19.1G has been constitutionally superseded by 15.5 because this answers those 5-6 exceptions to 19.1G which are laid down in 19.6. But then, having said this and having upheld the provision, the Supreme Court goes on to introduce some checks and balances to prevent abuse of this provision by the states while making laws. So the Supreme Court said that if a law is made under 15.5 purely for appeasement of certain classes of society who are not falling within scheduled caste, scheduled tribe, or socially and economically backward class, and just to give them reservations, if it is done, that will be unconstitutional and that will be struck down. They also held that though this 15.5 is valid and though it applies to aided as well as unaided institutions, and there can be reservations which are given for socially and educationally backward classes, even in private unaided institutions, they said that if it is given in private unaided, if it is imposed on private unaided institutions, then they will have, those institutions will have to be compensated by the state. So they put in a monetary check and balance, which is that if you are, so far as aided institutions are concerned, if you impose a reservation on them, it's okay because you are giving aid. So anyway, the state will be giving them aid and they'll get the money back from the state. But if they do this for unaided institutions, then they must compensate the unaided institutions for the whatever costs are incurred by them due to this reservation which is imposed on them. Certain such checks and balances are there. Then in Pramati, there was a challenge by one of the grounds of challenge was that the exclusion of minority institutions itself is a violation of Article 14 and of 15.1. That how can you, if you are saying that the socially and educationally backward classes require reservations, so much so that the reservation can, and scheduled caste and scheduled tribe, that the reservation can even be imposed on unaided private institutions, aided and unaided, then how can you exclude minority institutions? Supreme Court said, sorry, they said that minority institutions, because of Article 29.1 and Article 32, etc., 30 sub-Article 2, stand on a different footing. Their protections, the rival protections, the protection they get under 29.1 and 32 trump the requirement under Article 15.5, and therefore it is valid to keep them out of this sphere. So this is basically Pramati decided all these aspects of the of our what we are discussing today. Then comes the latest judgment, which I think is very, very important, and I'll skip over NALSA for the moment and just go straight to Punjab, State of Punjab versus Davinder, because as I said, our time is limited. State of Punjab versus Davinder Singh is 2025 1 SCC page 1, and this was before a 7 judges bench headed by Dr. D.Y. Chandrachud, CJI, and including within the bench Justice B.R. Gawai, who is the present Chief Justice of India, Justice Vikram Nath, Justice Bela Trivedi, Pankaj Mittal, Manoj Mishra, and Justice Satish Chandra Sharma. Now, in this judgment, the issue was that how does the creamy layer principle, because the creamy layer principle, if you flash back, I said that was evolved in Balaji, but it was finally sort of brought onto a pedestal in the case of Indra Sawhney in 1992. The nine judges bench in Indra Sawhney gave the principle, put the principle of creamy layer identification exclusion of the creamy layer from reservation benefit. But that had itself never really worked out because no state carried out proper exercise of identification and exclusion of the creamy layer. So there were conflicting judgments from time to time because the exercise itself was never done properly. When the exercise would be done, it would be struck down because it was done in a very haphazard or sketchy manner. So finally, this whole issue of exclusion of creamy layer, of identification of a creamy layer, whether creamy layer would apply to scheduled castes and scheduled tribes at all, that was a very burning issue because in Indra Sawhney, creamy layer was in the context of other backward classes. It was never in the context of scheduled castes and scheduled tribes because scheduled castes and scheduled tribes get a constitutional reservation under Article 16(1) itself, not under 16(4). So, in view of that, the questions which arose in this seven-judge bench in State of Punjab versus Davinder Singh are very, very important. And all the principles of can there be sub-classification within the class? That is the class of scheduled castes, scheduled tribes, socially and economically backward classes, and so on and so forth. Can there be sub-classification? If so, how can it be done? Can you identify the creamy layer and exclude them from scheduled castes and scheduled tribes? All these questions were framed and ultimately answered. Now, this judgment is very, very voluminous, and so the head note itself runs into some 100 and something pages. But if you see, you can come straight to page 156 of this judgment. And at page 156, if you see para 185, Chief Justice Chandrachud, as he was speaking for himself, and Justice Manoj Mishra, he summarized all the principles which were evolved over the years, and from para 185 onwards, he summarizes the principles. And para 220. Sorry, I hear some
Sorry, sir,
voices.
please continue and ask him.
So at para 220 and page 166, para 220, you will find Chief Justice Chandrachud's conclusions are set out, and see those conclusions because he sets out very succinctly all the various conclusions. At para 166, it's very brief. Page 166, para 220, Section E is the conclusions of Justice Chandrachud, Chief Justice Chandrachud for himself, and Justice Manoj Mishra. Most important, I think, is Justice Gawai's concurring opinion, which is a very, very detailed opinion. Now, Justice Gawai noted several aspects factually which had not really been highlighted enough, perhaps, in the past. His opinion begins at page 168 and goes on right till page 270 almost, from page 168 till about 270, more than 100-page opinion is Justice Gawai's. Now, at one very important part, you may note para 480 at page 262, because here Justice Gawai highlights some startling facts which had come to the notice of the Supreme Court. He said that why he said that identification has to be done. He said, for instance, though the presidential list for the state of Andhra Pradesh has a list of 60 scheduled castes, the Justice Usha Mehra Commission report shows that out of these 60 scheduled castes, only 4 or 5 had availed the benefits of reservation, leaving the rest of the scheduled castes in the presidential list high and dry. The report shows that the same has resulted in an anomaly that none of the majority castes, despite their inclusion in the presidential list for the state of Andhra Pradesh, have been able to seek reservation benefits, including entry into government service under the state, except for the job of sweepers and of harash. Similarly, he found that in state of Punjab, there was the same startling thing in various other states. So basically, he highlighted through actual facts and figures how only the it is in fact only the cream within those castes who were getting the benefit. The cream, even within, if there are 50 different castes, 60 different castes are scheduled castes, and only 4 or 5 of them are getting reservation. You can imagine that 55 must be really low down the ladder, so low that they can't even get a reservation, which is reserved for the scheduled caste. So, having highlighted all this, Justice Gawai, at page 265, after a very, very detailed discussion, and it's a superb judgment, but at section 6, para 496 onwards, begins at page 265, that how should the creamy layer principle be applied to scheduled castes and scheduled tribes. And he says categorically that the fact that persons within the scheduled caste. Now, keep in mind that Justice Gawai himself comes from a scheduled caste family from one of the lowest scheduled castes in the state of Maharashtra. But he says, look, once a person gets the benefit of reservations as a scheduled caste, that person's children stand on an altogether different footing from all the other members of that scheduled class. And therefore, he says, finally, that there is a necessity to identify to achieve equality even within the caste, you must keep out those who have already got the benefit and identify the creamy layer, exclude them, and then only give the benefit to the remaining members of that particular scheduled caste or that particular scheduled tribe or that particular social and so he says in para 516, he says, for instance, it is commonly known that disparities and social discrimination, which is highly prevalent in rural areas, starts diminishing when one travels to the urban and metropolitan areas. I have no hesitation to hold that putting a child studying in St. Paul's High School and St. Stephen's College and a child studying in a small village in the backward and remote area of the country in the same bracket would obviate the equality principle enshrined in the Constitution. I may note that some officers from scheduled castes and scheduled tribes who, after receiving benefit of reservation, have received high positions, are doing their bit to pay back to society. They are providing coaching and other facilities to less advantaged, etc. However, putting the children of parents from scheduled castes and scheduled tribes who, on account of benefit of reservation, have reached a high position and cease to be socially, economically, and educationally backward, and children of parents doing manual work in villages in the same category would defeat the constitutional mandate. And then he gives a mechanism which he evolves that how it should be done to exclude the creamy layer. And Justice Gawai's conclusions, you must read those at page 270, section 7 is his conclusion. And I believe that he has very neatly, in a very short passage, he has summed up the entire legal position. Now, Justice Vikram Nath and Justice Satish Chandra Sharma ji gave very short one-paragraph concurring opinion, though they wrote separate opinions, but very, very short. Briefly, Justice Pankaj Mittal gave a detailed concurring opinion, and Justice Bela Trivedi was the only learned judge who dissented and gave a very detailed and well-reasoned dissent. But I personally feel that that dissent misses the point altogether, and I think it is incorrect. I believe that Justice Gawai's judgment here is really, though he's speaking only for himself, his concurring opinion is even more important than CJI Chandrachud's main opinion, in this judgment, and that is really worth your while to read that. So I've dealt with all the judgments except NALSA. Now, NALSA is a judgment which is belongs to an altogether different class from what we've been discussing today. That is NALSA's National Legal Services Authority versus Union of India 2014 5 SCZ 438. And here the Supreme Court was dealing with the issue of transgenders. People who are transgender, people who are outside, who are kept outside the pale, not because of caste, not because of their creed, not because of their religion, not because of their language, but because they are their sexuality they believe in a different sexuality. They may believe that I'm a man in a woman's body or I'm a woman in a man's body. Their life is completely turned topsy turvy and upside down because of that, and they are left at the mercies of society. They are begging on the streets and so on and so forth. Justice Raja KSP Radhakrishnan, who authored the judgment, it's an absolutely brilliant judgment. I think Article 14 has been Article 14 and 15, but particularly Article 14 has been so well expounded in this judgment, and how equality should be actually worked on the ground. And reading Articles 14 and 15 together, Justice Radhakrishnan evolved the need for framing, for actually having affirmative action and positive interventions in favor of transgenders to bring them into the mainstream, to reserve seats for them, etc., and to find ways and means of uplifting them. And they ultimately, para 83, Justice Radhakrishnan said, we therefore conclude that discrimination on the basis of sexual orientation or gender identity includes any discrimination, exclusion, restriction, or preference which has the effect of nullifying or transposing equality by the law or the equal protection of laws guaranteed under our Constitution. Hence, we are inclined to give various directions to safeguard the constitutional rights of the members of the transgender community. And Justice Dr. A.K. Sikri gave a concurring opinion where he has also, with his customary, lucidity, also concurred with Justice Radhakrishnan. So this, as I said, the judgment, it's a very, very far-reaching and an outstanding judgment on equality rights in India. But of course, stands on a slightly different footing from the others that we have discussed today. So that, I think, completes what I had to say. And in case there are any questions, I'll be happy to take them.
Thank you so much, sir, for such an enlightening lecture. I'll just start taking few questions. Just a minute. I'll just start taking few questions. So there's only one question, and it is, sir, how is his newly delivered judgment in the Aligarh Muslim University matter, which upheld the university's minority status, connected to the TMA Pai and PA Inamdar judgments?
So while examining the question of the minority status of Aligarh Muslim University, the 7 judges bench, which was the lead opinion is by Chief Justice Chandrachud again in Aligarh Muslim University. There's a dissenting opinion by Justice Suryakant, but Chief Justice Chandrachud, if I remember right, perhaps speaks for himself and the 5 other judges. There might be some concurring opinion, but if memory serves me right, it's only Justice Chandrachud who gave the main opinion. So while examining whether taking away the status of Aligarh Muslim University or grant of status as a minority institution is concerned, the Supreme Court had to go into the issues which had been examined in TMA Pai, etc., to the extent of that what sort of interference can there be in an institution when it is a minority institution or it is not a minority institution. So in that context, they went into and on that aspect, that there can be no interference with minority institutions except for excellence of education, except for prevention of maladministration, except for maintaining minimum standards, and so on. There, even Justice Suryakant's dissent and Justice Chief Justice Chandrachud's majority opinion follow they are absolutely on par with each other. Even Justice Suryakant does not dissent on that aspect. So in Aligarh Muslim University, I haven't opened it right now, but I'm broadly familiar with the judgment. The court ultimately holds that by majority that it was founded as a minority institution, and that merely because it admits non-minority students, merely because it is run as an institute of national excellence under government control and so on, does not rob it of its minority character. And the majority then holds that it continues to be a minority institution. And Justice Suryakant, of course, holds that it is not a minority institution, that the state has virtually taken over pervasive control. And because of state control, it ceases to have that minority character, and it is now an institution of excellence, just like JNU or XYZ, various other institutions. But they have dealt, to answer the question, basically they have the majority as well as the minority opinions have dealt with this issue of extent of interference with minority institutions, as laid down in TMA Pai, as laid down in PA Inamdar, etc. And that has been reiterated very, very clearly by both the opinions.
Thank you so much, sir. I would now request our president, Vipin sir, to please conclude with this session.
The absolute pleasure to hear you. And in our country, where you have religious, linguistic minorities and religious minorities, the interface has to be a little complicated. For example, as you yourself had said, Christians may be a minority all over India, but in Mizoram, they have 85%. So it has its own unique, our country brings on those diversities together. And that is beautifully the unequal treatment of unequals. You just brought it. And particularly grateful for you having referred in detail to Justice Gawai's landmark judgment, actually. He goes much against what the tide is, and the identification of minority is absolutely essential in order of the day. Thank you so much, sir. And I'm very sure it will be a great help to all our aspirants and to us also to just hear you.
May I just wish all the aspirants all good luck, and may they all do very well in the forthcoming exam.
So I would now request Aditya Giri to please give the vote of thanks.
Thank you, Meenakshi. On behalf of the entire SCAORA Executive Committee, I extend my heartfelt gratitude to CU Singh sir, Senior Advocate, for his generous commitment of time in delivering an insightful lectures on 6 landmark judgments to our AOR aspirants. Sir, your expertise and insights have greatly enriched our understanding, not just of the case laws, but also of their latest application by the Supreme Court, and will undoubtedly guide the aspirants in their upcoming exams. As this concludes our lecture series, we wish all our colleagues who are aspiring to become AORs the very best of luck in their examination, and we look forward to welcoming all soon as esteemed members of the AOR community. Thank you, sir, once again for your invaluable contribution to SCAORA. Thank you so much, sir.
Thank you, sir.
Thank you. Thank you.